You state your name. Colette Haynes.
All right.
Thank you. In regards to the PCC, Your Honor, we are requesting an adjournment just for some continued negotiations.
All right. With reference to the violation.
Yes, Your Honor. Ms. Haynes is prepared to admit to the bond violation today and provide an explanation.
All right. I'll accept the admission, but what's the explanation?
Your Honor, it does state in the bond violation report that on the 22nd, when she reported she was visibly ill at the time, she explained to me that she has diabetes and shortly after that went into DKA and did have to be hospitalized for a few days. So unfortunately, she ended up missing that new scheduled appointment as well as her first PCC. After missing the PCC, she did contact me and we worked to get this case set to do a bench warrant recall. So she is willing to test. She is willing to comply on bond. She is sorry that she missed that appointment and she's hoping to have an opportunity to go touch base with community corrections today and reschedule.
Thank you.
But okay, I hear what you're saying, but when I look at this, all of the events that I have in this occurred at basically toward the end of September.
Yes, Your Honor.
I'm now almost 30 days out and nothing's been corrected.
And Ms. Haynes indicated to me that she wasn't aware that she needed to make contact with community corrections because she had the bench warrant.
I didn't know that I can just go back there and.
Yeah, but once the bench warrant was cleared, that doesn't even make any sense to me.
They told me that I had to wait when first they told me I had to do it online.
Do what online?
For the bench warrant.
That's fine.
Yeah, and I didn't know that the warrant was cleared until I come to court today. And I thought I needed another referral to go back to community corrections. I didn't know I could just walk back in there and do it all over again with a warrant. I tried to come up here and walk in on a warrant, but they told me that they only do it once a month, at the end of the month on Wednesdays. And that would have been yesterday, but I had received
Yeah, but where were you between that? All of this occurred September 2nd. I get what counsel's telling me, that at some point you're in the hospital for a few days. So even if that takes me to the end of September, which is giving a lot of grace just in terms of time, I'm now here on the 23rd and nothing.
Because they told me that I could not walk in on the warrant. And I didn't know that I could just go back to community corrections.
You have an attorney.
Mm-hmm.
And Your Honor,
I was contacting the attorney, and when I was contacting the attorney, she was telling me that she didn't even, well, it was a he. It wasn't even her. It was a whole different attorney I had. We were texting back and forth and I was asking him questions and he was saying he was in court. He don't know, he'll find out. And then he told me I could do it online. So I just did it online.
and Your Honor, I will say Ms. Haynes does want to resolve this case. She did make steps to take care of the bench warrant and to get the case back on track. So she's just hoping for another opportunity.
She's here on a drug case. Since the beginning of the case, she hasn't tested.
Understood, Your Honor.
I hadn't tested, Your Honor, because I didn't know that I could just, by me missing mine, I didn't know that I could just go walk back in. I thought I needed another referral. Or I would have went over there and walked in and tested.
Not as though you didn't have an attorney, whether it be the previous attorney, whether it be Ms. Foster Tucker, to tell you what you could do regarding community corrections, if anything. But, you didn't abide by community corrections. You didn't appear in court. You get the court thing cleared up, but then you had the other thing. And I still, from the time of year, I don't have a test on you.
I can go take one today. I can go over there right now when I leave here. But I just need to know, am I
Anything you want to
assigned?
say? I will adjourn her probable cause conference to October 30th, 2025, 9 a.m. Anything you want to say before I send you on the violation?
No, sir.
Well, at this point, she's not complied with everything. I'm going to revoke her bond, sentence her to 7 days, Washington County Jail. Defendant's remanded.
Is there a way that I can get somebody? I have my daughter here with me,
Ma'am, you probably shouldn't have done that.
but she only had a half a day of school
Here,
today.
ma'am,
Come on this way.
they'll figure it out.
Okay. Let me get her this. Yep, I'll give it. Come on back.
Ma'am, go with my bailiff now. Now.
Wow, that ending escalated quickly. Let's break down exactly what just happened, because there's a lot to unpack here legally, emotionally, and strategically. In this case, Colette Haynes was out on bond, which means the court allowed her to remain free until trial under conditions. One of those conditions was mandatory compliance with community corrections, including drug testing and scheduled check-ins. These aren't optional. When you're on bond, your freedom is essentially a contract. You get to stay out, but only if you follow every instruction to the letter. According to the courtroom exchange, Colette missed multiple required appointments. The defense explains that she was hospitalized due to diabetic complications, specifically DKA, and that she thought she needed permission or a new referral to re-engage with community corrections. That's her reasoning for nearly 30 days of silence. But here's where the judge shuts it down. The judge points out that even after being released from the hospital, Colette made no attempt to clarify her status or follow up with community corrections. Whether she misunderstood the process or not, she had an attorney, and the court expects defendants on bond to be proactive. The message is clear. You are responsible for staying on compliance. No excuses. From a legal standpoint, the judge's reasoning is based on compliance versus intent. Bond decisions aren't about whether someone intended to follow the rules. They're about whether they actually did. Courts can't manage bond conditions based on assumptions, misunderstandings, or personal struggles. If defendants could violate terms and justify it with confusion alone, the entire bond system would collapse. Colette tries to explain that she thought she needed a new referral before going back to testing. She blames misinformation and miscommunication with prior counsel. However, the judge emphasizes that she had legal representation the entire time. The court essentially says, if you didn't know what to do, your attorney could have told you. But what you cannot do is do nothing. And then, there's the emotional gut punch moment. When the judge revokes her bond and orders 7 days jail time, Colette reveals that she brought her child to court. That shows unpreparedness. And from the judge's perspective, it reinforces the concern that she may not be handling her responsibilities optimally. Judges absolutely do not like being put in a position where a child is potentially stranded because a parent is taken into custody. Here's the takeaway. Bond is conditional freedom. If you don't meet those conditions, even unintentionally, the court will revoke it. Confusion, miscommunication, and personal hardships do not override failure to comply. It's harsh, but that's how the system works. So now, I want to ask you, do you think the judge was too unforgiving? Or was he right to enforce the bond terms strictly? Drop your opinion in the comments. I genuinely want to hear what side you're on. And if cases like this fascinate you, where real lives, real consequences, and raw courtroom pressure all collide in real time, then you're in the right place. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. This case reminds us, courtrooms care about compliance, not excuses. And freedom on bond? It's never guaranteed. Stay tuned, because the next case is already being called.